And turning to the topic of our discussion, my non-lawyer friends, when saw me so excited before the event, asked me, "What's the reason for it? Why are you so gobsmacked?" And the best analogy I could come up with was the following. Imagine being a young, aspiring rock singer, and suddenly Patti Smith and Mick Jagger come to your country and invite you to participate in the event. So this is the kind of the excitement that we all have, and this is the kind of the legal rock stars that we have here in this room and at this particular panel. So please let me introduce the first legal rock star. This is the Professor Sean Murphy of the George Washington University Law School. He worked in The Hague. He argued several cases before the ICJ. He advised the US Department of State on international law matters. And there are many, many other positive things about him that I could enumerate. But today you have a special treat from him because he's also a special rapporteur of the International Law Commission on crimes against humanity. So basically, today you have here the person who is responsible for bringing into life the legacy of Hash-Lauterpact in the form of the Convention on Crimes Against Humanity. So the floor goes to Professor Murphy.
Well, thank you very much, Kateryna, for that wonderful introduction. I wish my children were here to see me introduced as a rock star. Fortunately, my wife is here, so when I tell her I'm some kind of rock star, she'll now maybe believe me. I don't really feel that way. I feel like someone who's just tried to pursue the field of international law in whatever way I can be of some service. And as Kateryna said, right now I'm a member of the United Nations International Law Commission. That is a body of 34 international law experts elected by the UN General Assembly from around the world. I'm the American on the commission. And when you're running for election, and you do have to campaign for such a thing, I met for my first election with 97 countries to ask for their vote. And in the course of those meetings, a question I would often get is, well, if you're elected, what would you do on the commission? What would you try to bring to the commission as a possible topic for it to work on? And if you're not familiar with the commission, it basically studies about 10 topics at any one time for the purpose of drawing upon international treaties, national laws, jurisprudence at both international and national courts in order to develop a series of draft articles which are accompanied by commentary explaining where the draft article came from. And these draft articles are then eventually sent to the UN General Assembly in the hope that they are transformed into a treaty. So if you're familiar with, for example, the Rome Statute establishing the International Criminal Court, the International Law Commission did the first draft of what became the Rome Statute. And there are a series of other treaties that are foundational to the field of international law that in their first iteration came out of the commission. So when I was asked that question, I immediately wanted to be able to respond with a project that I thought would be of great value to the international community. And the idea I had was to do a convention on the prevention and punishment of crimes against humanity. If you're familiar with the field of international law, you may be aware that we have a convention on the prevention and punishment of genocide. You may also be aware that in the 1949 Geneva Conventions, there are provisions about preventing and punishing war crimes. But we have no global treaty that's focused exclusively on crimes against humanity. And it's an interesting story as to why that's the case. But basically, for these three major crimes, war crimes, genocide, and crimes against humanity is the only one that we don't have a global convention addressing it. The Rome Statute, which created the International Criminal Court, addresses all three crimes and may soon also address the crime of aggression, but it is focused exclusively on the creation and operation of the International Court itself based in The Hague. It says nothing about national laws, national jurisdiction, nothing about cooperation between states on matters such as extradition or mutual legal assistance. So what we have is a system right now where there is no treaty calling upon states to develop national laws on crimes against humanity, to exercise jurisdiction over the crime, or to be in a relationship with other states in the enforcement of that effort to prevent and punish. So my idea was the International Law Commission should take this topic up. And the commission thankfully agreed with me on this when I was elected, and we began 3 years ago in drafting this convention. So we have this past August finished a full first draft of what might be a convention on crimes against humanity, and I have circulated copies of this first draft around the room. There are a few still on chairs here in the front. There may not be enough for everyone, but I hope that most people were able to get a copy of it. And you will see on what I circulated, starting on page, the second page, it's labeled page 10, the beginning of this draft convention. There's a preamble. There's a series of articles from 1 to 15, and then an annex at the very end. A lot of detail in there that I'm not going to go through for you, but I do want to highlight some of the basics of this. And part of my purpose is I think we are interested in talking about the legacy of someone like Hirsch Lauterpacht, who originated in this part of the world with his family and went on to successfully include the crime of crimes against humanity in the Nuremberg Charter because of his relationship with the prosecutors, including Robert Jackson. In talking about his legacy, I think part of the story is that even today, we continue to be trying to develop laws and institutions that will operationalize this concept of crimes against humanity. So what we have in this draft is a effort to get states to adopt national laws and jurisdiction. Is it really necessary to do this? Before I embarked on the project, my university, George Washington University, did a study, and we found that in looking at the national laws of states worldwide, about 50% have no statute of any kind relating to crimes against humanity. The countries that do have a statute, when you look at it, sometimes their statute on crimes against humanity has nothing to do with crimes against humanity. It may have something to do with war crimes and other types of crimes, but not crimes against humanity. Even if it is speaking to crimes against humanity, many of these statutes were adopted in the 1950s and the 1960s at a very early time in our conception of what crimes against humanity are. And if you were to compare those statutes to something like the Rome Statute, which has a very robust definition as to what constitute crimes against humanity, many of these early national laws are very incomplete in terms of exactly what they're covering. So our study found that national statutes worldwide either don't address crimes against humanity or they address it in a very incomplete way. And when we also looked at what types of jurisdiction could that country exercise, oftentimes it was limited to situations where the crime occurred in that state's territory or was committed by one of that state's nationals, but didn't cover many other situations, such as if the crime occurs abroad, by a non-national against a non-national, but the alleged perpetrator turns up in your territory, there often was no jurisdiction to prosecute that type of alleged offender. So this draft treaty that we've done the first draft of tries to get at all of those issues. First of all, we have a definition of crimes against humanity. It's in draft Article 3. It essentially replicates the definition that appears in the Rome Statute. So it's a very modern formulation of what crimes against humanity constitute. There's then an obligation in draft Article 6 for states joining this convention to include this in its criminal code, include this definition in its criminal code, and also to do certain things, such as provide for command responsibility. If you're a general or even a senior civilian leader and you order someone to commit crimes against humanity, you yourself are culpable for the crime. Or if you're aware that someone under your leadership commits a crime and you do nothing to punish them, you become culpable yourself. That's the idea of command responsibility. Likewise, in draft Article 5, the idea that you cannot plead as a lower level person that you were ordered to commit the crime by a senior official. You can't raise that superior orders defense is something that would be barred under national law. No statute of limitations permitted with respect to the crime and other matters as well. And then when you move into draft Article 7, there's a establishment of national jurisdiction that would include prosecuting individuals that turn up in your territory that committed the crime elsewhere. Other provisions allow you to avoid this obligation to prosecute if you extradite to another jurisdiction prepared to prosecute. That's a concept known as aut dedere, aut judicare, extradite or prosecute, which means that if someone's trying to hide out in your territory and the country where they did the crime wants that person back to be punished, you can extradite to them and thereby avoid your obligation to yourself prosecute. Draft Article 12 talks about victims, witnesses, and others. It's viewed as very important that when you conduct these national prosecutions, that you give an opportunity for victims and witnesses to come forward, to make complaints to authorities, to not be exposed themselves to any repercussions from coming forward, and in appropriate circumstances to be involved in the actual prosecution as a witness in the proceeding and so on. There's also provisions relating to reparation in draft Article 12, which are quite important. And then fairly lengthy articles on both extradition and mutual legal assistance. This gets into the bit of weeds as to what international lawyers do. But when it comes down to it, when you're trying to have states engage in important cooperation, gathering information about what occurred in what place, and perhaps have witnesses coming from across borders to testify, it's very important that you structure that in a way that allows the cooperation to move forward without any difficulties. Likewise, with extradition, there are various rules that you need to try to overcome relating to doctrines of political offenses or dual criminality and things of that sort. So we have in our draft Article 13 and 14 provisions on that. Finally, a provision that talks about when disputes arise under this convention, the two states that may be in a dispute could take the matter to the International Court of Justice. So you may be familiar with Bosnia's case against Serbia relating to genocide. Why did they focus on genocide? It's because there's a genocide convention providing for the court's jurisdiction. Why did they not focus on crimes against humanity? It's because there's no crimes against humanity convention providing for the court's jurisdiction. So you can see how this is trying to fill in a gap. In the couple minutes I have left, I'll just say where are we headed in the future for this convention. The first full draft is done. That's what we have here. Governments international organizations and NGOs, non-governmental organizations, and individuals are invited to send in comments about this draft over the next 12 months. So by December of 2018, we'll have a full set of comments from governments and others about what they like and don't like with respect to our draft. We will then, the International Law Commission will then, in the summer of 2019, return to this draft. We meet in Geneva, return to this draft and modify it based on the views we've received from governments and others to create a final version that we then send to the General Assembly for them in the fall of 2019 to decide whether to turn it into a treaty. So my hope is, to the extent there are any Ukrainian government officials in the room, that they will support this matter being taken up as a treaty by the General Assembly. My hope is, if there are representatives of NGOs in the room, they will be promoting the adoption of this as a treaty, and even individuals here, civic society generally speaking, voices are important here in influencing governments and others. I hope that you'll all agree this is a worthwhile endeavor. If we can, in the fall of 2019, we would be in a position of launching a diplomatic negotiation to finalize this so that it's adopted, states can start signing it and ratifying it, and then begin the process of implementing national laws as the next generation of steps to be taken to address crimes against humanity. Thank you so much.
Thank you so much, Professor Murphy. Indeed, Ukraine has a draft law implementing international crimes, including crimes against humanity, in its criminal code. So I think the fact that such work is being done within the International Law Commission, and if the convention is hopefully adopted, I think it will have this catalyzing effect on our legislators, hopefully, because it still takes us too much to amend our domestic criminal legislation, and we need to do that, given Donbass and Crimea. I will now give the floor to Professor Laurie Damrosh from the Columbia University. She was also the president of the American Society of International Law, a highly distinguished and reputable scholar and practitioner. And Laurie will elaborate on another prominent Jewish son of Lviv, on Raphael Lemkin, and the way his concept of genocide was transformed, including in international jurisprudence. Thank you.
This is not, yes. Thank you very much. This is my first. Yes? No? This is my first visit to Lviv, but my second time in Ukraine. The last time, I won't say I was a very small person, but it was 1976, so the country has changed a lot. But we've been immersed since yesterday evening with Philippe's magnificent lecture and today's workshop in trying to absorb the lessons of history so that we can look forward to the future. And we're trying to learn from the past. And it's in that sense that we are looking back at these sons of Lviv, Hirsch Lauterpacht and Raphael Lemkin, and I was encouraged to turn to Lemkin as the father of this modern concept of genocide. And so for the first time in quite a few years, I took off the shelf from the library Axis Rule in Occupied Europe to remind myself about the full shape of the work and the full chapter. I turned to the preface. And irony of all ironies, the foreword to this volume was written by the then Secretary of the Carnegie Endowment of International Peace, a prominent leader of the American Society of International Law, one George Finch, deservedly famous now, but for a decade or more of his life, he spent fighting the Genocide Convention and saying that the United States should not become a party, and was successful in that quest, so that sadly the United States remained outside the framework of the Genocide Convention for 40 years. So when we look back and we try to ask, why has the Genocide Convention been ineffective, we can look at certain design flaws in the treaty itself, As Philippe had said last night, the Genocide Convention is, it's narrower, it's less ambitious than what Raphael Lemkin envisioned. And maybe if we'd adopted more of Lemkin's ideas, we would have had a more vigorous convention. But sadly, even with what we have, when we look at the record of what now is almost 70 years, we see that even with the tools that we have, they were not made effective. And I could say that maybe the non-participation of the United States for 40 years was one of the factors, with the United States having been blocked from a kind of constructive participation. But if we then turn to the efforts that began in the early 1990s to try to breathe some life into the mechanisms of the Genocide Convention, we see that those also were ineffective. So I would say that there was a period of approximately half a century when the Genocide Convention was entirely dormant. It came alive or started to come alive in the 1990s, and that's when we see its real flaws revealed, when we see that there was the will to try to put these tools into effect, but to very little results. And so now I'll show my actual age. I'm younger than Mick Jagger by quite a bit, but in the early 1990s, when serious efforts were being made to try to deal with several genocides that had recently happened or were happening or were about to happen, a legal problem came to me, and it involved an ethnic group, clearly a protected group under the Genocide Convention, the Kurds of Iraq. And they had clearly been the victim of prohibited genocidal acts in the late 1980s, from 1987 to 88, in the last phases of the Iran-Iraq war. The Iraqi regime under Saddam Hussein had used chemical weapons against the Kurds of Iraq on a massive scale. Tens of thousands, maybe as many as 100,000 Iraqi Kurds were exterminated either by the effects of the poison gas or by other techniques of killing. And so both from the point of view of the Kurds being a protected group and the acts resulting in deaths on a massive scale and the apparent genocidal intent of trying to destroy the Kurds of Iraq in whole or in part as an ethnic group protected by the convention, there was a plausible case. And so the NGO, the non-governmental organization Human Rights Watch, came to me and said, we want to try to do something with this. And we've looked at the Genocide Convention, and it says in Article 9 that any state party to the Genocide Convention can take a case to the International Court of Justice involving the interpretation or application of the convention. Can we make this case here? So I wrote a legal memo, I think it was about 25 pages long, saying, yes, well, there's the case on the facts and the law. It's there, and the forum is there. And all you need to do is find a state party to the Genocide Convention that will be willing to initiate such a lawsuit. And we convened a series of meetings in 1993 in New York and Washington with legal advisors, not as many as the 90 that Sean has referred to, but maybe 20 or 30 or 40, looking to find a state party to the Genocide Convention that would be willing to bring such a case. And no such state party ever surfaced, and that case was not brought. However, there was then a sort of mini renaissance in that Bosnia and Herzegovina was willing to bring a case against what was then known as the Federal Republic of Yugoslavia, Serbia, and Montenegro. And that case was brought in 1993, resulting actually in a provisional measures order saying to Serbia and Montenegro, don't commit genocide. But we see that no actual deterrent effect was found from the bringing of that case. Some years later, Croatia brought a similar case. The Democratic Republic of the Congo tried to bring a couple of cases, 3 of them altogether, I think. One of them is well known in the law books against Uganda, another one against Rwanda. So there was all of this activity, but if we look back to try to say, were there any real-world effects in terms of either preventing genocide, which is the main purpose of the convention, or establishing the responsibility of states for genocide, I would have to look back at what is now some 25 years of efforts to use the principal judicial organ of the United Nations and give a pretty pessimistic picture. Then at the same time, we had the creation of the first ad hoc tribunal, the International Criminal Tribunal for the former Yugoslavia, in 1993. And then in 1994, you had this paroxysm of genocidal violence within the space of a month in Rwanda, and about 800,000 to 1 million human beings were killed, and another special tribunal was created to try to do justice for those crimes. And so the creation of these criminal tribunals was definitely a milestone. They led to the trends that eventually brought us a few years later, the Rome Statute for the International Criminal Court, and the creation on a much more general basis of what was the idea in the original 1948 convention of having a standing tribunal that would be an international penal tribunal in which the crime of genocide could be punished. We look at all of these efforts, and it's a very mixed picture. So, for example, when the International Criminal Tribunal for former Yugoslavia was established in 1993, the hope was that the very existence of this tribunal would have a deterrent effect so that persons thinking of committing an evil deed might be deterred, specifically knowing that they could be prosecuted. Unfortunately, that proved not to be the case. The Srebrenica massacre, which was later established to have been a genocide, was not prevented by the existence of the tribunal, nor have genocides been prevented by the existence of the International Criminal Court. So in my last few moments, 3 minutes or less of dwindling time, I just want to turn to the preventive dimension of the convention, because I think that it would be sad if we would say, first of all, there's been very little punishment, period, but it's not enough if there were to be successful punishment to say, well, we've now punished for the killing of hundreds of thousands or sometimes millions. It's better that there be punishment after the fact than that there be no punishment, but what is really needed are the preventive tools, and that's where we really need to look in a forward-looking way into the future and try to activate these tools. So some of you may have read the wonderful book written by Samantha Power back when she was a journalist and a lawyer and an activist before she became the U.S. permanent representative to the United Nations. It was called A Problem from Hell. And she wrote about how so many governments, and the United States government worst among them, they were so reluctant even to name and shame for a genocide in progress. And one understands a little bit of the psychological reluctance for doing so, because there is an argument that once you've called something a genocide, that maybe then there's an obligation to do something about it, and nobody really knows what to do to interrupt a genocide in progress. Samantha Power pointed out that even the sort of modest repertoire of things that we now know pretty well how to do, like how to use targeted sanctions against the perpetrators of genocide, had rarely been done in the 1990s or into the 2000s. Now we have a better sense of how to figure out who's actually committing the acts and try to sanction those individuals to stop them from carrying out the acts. But the final thing, and this is the hardest to deal with, and it's certainly the hardest to deal with on the plane of policy, but it's also very hard to deal with on the plane of law. And that is, how do you interrupt a course of conduct that has started and that is taking place on a scale that's going to qualify as genocide when the only thing that actually can meaningfully interrupt massive violence in progress is the application of legitimate, lawful military force to stop it. And that's where we haven't really figured out how to do this. So the whole effort leading up to the pronouncement of a doctrine called responsibility to protect was aimed at trying to design a legal framework for preventing and interrupting atrocities before they would reach the horrible scale of some of the atrocities of the past. And in 2005, the United Nations General Assembly, acting at the level of heads of state and government, came together and said, we're going to accept a responsibility to protect, and we commit ourselves, and we're going to exercise this responsibility through the Security Council. And genocide was specifically named as one of the atrocities that there would be the responsibility to protect from. And here we are a dozen years later, hearing, unfortunately, arguments about sovereignty and domestic jurisdiction that are said to stand in the way of the Security Council taking action against some of the most horrific genocides of our time, the Yazidis, the Rohingya, and others being among them. And when permanent members of the Security Council say to the Security Council that those are matters of internal jurisdiction as to which the Council should not act, I think that is a flawed legal argument, and one that we as lawyers and law professors and law students in this generation should apply all of our creative faculties to trying to overcome. Thank you very much.
Thank you very much, Professor Damrosh. And now the floor goes to Dr. Ivan Horodysky. He's the director of the law school of the Ukrainian Catholic University and one of the two, I suppose, lawyers who have been from the very beginning with Professor Sanz helping research from the very beginning, the roots of Lauterpacht and Lemkin from this city. So Ivan will continue commenting on the legacy of Raphael Lemkin and how it stands in contemporary jurisprudence. Thank you.
Thank you, Katya. I don't think there was at the very, very beginning of Professor Sanz's work on the Lemkin-Lauterpacht, but I had the luck to join it in the long run. First of all, I want to express some hope. Hope then is that one day we will have no need to discuss the possible further implementation of the ideas and legacy of Lemkin-Lauterpacht just because all what is needed will be implemented. But still, in this case, I'm a little bit pessimistic, and I think that if we will see that all these ideas, their concepts, their ideas, their vision will be implemented, it will take a long way, and it will need a long effort from different stakeholders. And Sean mentioned currently that NGOs, academics, states, they all subjects or persons who have goodwill need to unite and to cooperate in that direction. First of all, concerning speaking of on Lemkin's heritage, legacy, and its possible further implementation in international law, it will be kind of complementing what Ms. Damrosh has stated. Before that, I had studied and read practically all what is in the public access works of Lemkin. There are not too much, and it took only 1 or 2 days when you just paying attention to it to read it all. He started his academic career only in the later stage of his life, and still, as it was mentioned today also by Philip, that and yesterday it was mentioned that Genocide Convention the father of which was once stated Raphael Lemkin, is a very narrow and has a very narrow definition of genocide, of general concept of genocide, comparing to those which is in Lemkin, which was in Lemkin's vision, and it's Lemkin also on the latest stages and his memoirs, he stressed that still many ideas were not implemented. One of these ideas was today presented concerning cultural genocide, was today presented by Markian Bam. But still, among other ideas which can be at least discussed is, first of all, it can be named the idea of expanding the list of groups, the existence of which can be an aim, a goal of acts of genocide. This means, as for me, in my opinion, it means it can mean not only just to technically add that not only national, racial, but also groups groups which have some sexual identity, which have some cultural identity, and so on. But for me, the key words is existence. Because in the vision of Lemkin, which is many times stressed in his Axis rule, the existence means not only, his existence is not only in a physical or biological sense. The existence, first of all, is identity, or he also uses a lot a word pattern. So when, in his vision, group can stop its existence, not when just everyone is dead and any representative is dead of this group, but also when the identity is destroyed and identity is lost. And we have seen a lot of such examples in the history. Before 20th century and in 20th century, and probably we can see it as an example of even Rohingya group, which was mentioned. I think that main idea is also to make them forcibly be assimilated in the societies, and to protect from such acts which from one point of view they're a little bit softer than killing, but in the long run they mean also that the groups should be destroyed by losing their identity, religious, cultural, social, and so on. The second thing which can be effective is a creation and which was proposed by Lemkin. He had, as far as I can remember, he had no direct idea and direct proposals. Is the creation of this institutional mechanism of prevention of genocide and monitoring of over the implementation of Genocide Convention. As far as I remember, he has no direct idea of how such a institution, international body, can be called, what should be its structure. He suggested in that time to such an powers should be transferred to the international court, which will deal with criminal issues of future. Currently we have ICC. But still, it's very needed, as for me, as practice shows, to have an independent body, an independent national body, which will monitor the general situation and will stress the international society attention on the facts which can constitute genocide, as well as provide an evaluation of the effectiveness of prevention of genocide and other steps which are taken in accordance with the Genocide Convention. Once again, even maybe for British governments, the decisions of such commissions can be enough to clarify this act was genocide, as Philip provided an example during his lecture, lectures yesterday. Also, what's more important, besides such more or less global ideas, Lemkin has suggested a couple of technical things to improve the general content of the Genocide Convention. For example, he was he was disappointed that still there are some terms put in this convention that in case if just in case if state is not saying that it's out of the convention automatically is renewed for the state for the next 5 years. So he was against this. He was against this norm and wanted to be excluded, and that there should be general participants of the state in the convention. Also, issues of universal jurisdiction over the genocide and so on. But as for me, also one more thing. On the later, in the end, I want just to say a couple of words of if there are possibilities to these ideas to be implemented. For example, taking the expanding of the list of groups, the existence of which can be a goal of genocide. As for me, I have certain doubts. I just believe that project of the Convention on Crimes Against Humanity has bigger perspectives, but in case of, I think that in the nearest future, in the nearest decades at least, or decade, we'll be doing with this narrow concept of genocide, which is included in the Genocide Convention 1948. And once again, I want to refer to Philip, to one of his answers. It was 6 years ago when it was concerning the advisory opinion of the ICJ on prohibition of nuclear weapon and the content of that advisory opinion, and why it was why the advisory opinion was as it was adopted by ICJ. And Phillips said what you can wait for the International Tribunal where five judges of 5 nuclear states, China, Russia, and so on, so on, so on. So once again, I think the same logic that still there are great states, big states, still they, and which are main stakeholders in that sphere of national law, they won't be very welcoming the expanding of the genocide concept and any improvements of the Genocide Convention, but still it doesn't mean that society should stop. We need to make efforts and to push in order, and we have this very symbolic figure of Raphael Lemkin and also very, very symbolic figure of Herschel Lauterpacht to inspire us in that way. Thank you.
Thank you very much, Ivan. And returning to Herschel Lauterpacht and the lawyer who actually gave rise to contemporary international human rights system, I will now give the floor to Hanna Yudkivska. Hanna Yudkivska is a Ukrainian judge at the European Court on Human Rights. She's also very cherished for her innovative jurisprudence, I would say, in Ukraine, because she sets the example to our judges on such issues as gender equality, protection of the rights of the child. And what's more importantly, for the Ukrainian students, law students and journalists, she provides very insightful comments on her Facebook page about the legal details. So if you would like to have a concise analysis of contemporary human rights jurisprudence, please follow her on Facebook. I mean, she's really helpful in that. Currently, Judge Yudkivska has chosen a very particular topic to speak, the efficiency of international jurisprudence, of international courts, and the critiques that not only the ECHR receives. So I give the floor to Hanna Yudkivska.
Thank you very much. Thank you, Kateryna, very much, also for advertising by Facebook. But, well, actually, what I would like to add today to this brilliant panel is a little bit of European, not to say pessimism, but a little bit of concern to share with us and to maybe reflect together. What we have today in Europe, if we consider, it's a dream of Herschel Lauterpacht materialized. We have brilliant system of human rights protection. We have European Court of Human Rights, which is called to supervise, so to say, commitment of the member states to human rights. But did it save us? at the end of the day, from dramatic U-turn in democracy, which we witness, unfortunately, today. And of course, we find today ourselves at the crossroads of different crises. We have economic crisis, we have migration crisis, we have territorial armed conflicts in Europe, we have rise of terrorism, and all those crises resulted on the one hand, we received an enormous amount of new applications to the court. We have roughly now around 100,000 cases pending. But on the other hand, this crisis has provoked terrible wave of populism, which is very far from our perception of democracy. And I believe that Herr Schlotterpach could not imagine that after such a triumphant era for human rights in Europe, this awful backlash would emerge. Well, of course, the situation maybe is not so dramatic if we compare to other regions. Well, in inter-American system, 2 states already left system, you know, Trinidad and Tobago in 1998 and Venezuela more recently in 2012. You know, well, the crisis of ICC. Still in European system, although some states threaten us with the exit, but for the time being, no denouncement of the convention took place. Of course, some cases provoke disagreement, but one thing is to disagree with the judgment, and another thing is to leave the system. But the problem is that, unfortunately, we cannot take for granted anymore that all European states are democratic. And when we consider our role as international judges, business as usual does not work anymore, so it's not sufficient. And we cannot simply address legal problem as we used to do so in isolation. We have to look closely to the context. In other words, we have to see forest behind the trees. And the issues before us not concern just human rights and rule of law. We are talking again about perversion of democracy. And Herr Schlotterpach and fathers of the Human Rights Treaty saw this Human Rights Treaty more as interstate pact against totalitarianism than anything else. And, well, he and other drafters, I quote, have been driven by a broader agenda to contain democracy in the hope that a supranational human rights system would safeguard liberal democratic institutions. Did it happen, in fact? Well, nowadays we can see that being under jurisdiction of the European Court of Human Rights does not prevent liberal democracy from producing xenophobic discourse, from producing far-right regimes, and practices which are not compatible at all with human rights and democracy. And Eric Posner had recently sarcastically written that the European Court of Human Rights had presided over a turn of authoritarianism to Russia. Well, it's of course sarcasm, but it's true not only for Russia, but unfortunately for other member states. And many states, unfortunately, demonstrated move towards this direction, still being member of the convention. And isolation of highly repressive regimes within the Council of Europe member states did not take place. And even though, for instance, Russia and Azerbaijan treat us with leaving the system, it's highly improbable that this will take place. And I want to tell you about a very important study done by Harvard professor Beth Simmons. She issued it some years ago, Mobilizing for Human Rights, why states ratify human rights treaties and why they comply with human rights treaties. And she suggested that the governments are more likely to ratify human rights treaties when which they believe in and with which they can comply at a reasonable cost. But political benefits should obviously exceed the costs. And we have a perfect example of that with Eastern and Central European states, where the convention was ratified by these states at the moment they desperately needed to be accepted into European family with all political and economical benefits of that. And they received these benefits. And applying Simon's theory to European backlash against the European Court of Human Rights, we can say that, well, convention system will be successful only when it is clear for national authorities that the cost they would bear by changing relevant legislation in practice in order to bring it in accordance with the convention is less than the cost of non-compliance with the court judgment. It doesn't mean that changing the legislation in order to be adapted to convention standards should be cheap. Vice versa, it means that non-compliance should be always expensive and costly. And we can see these examples. Now, we have Azerbaijan, who refuses to release well-known political prisoners, even though the European Court of Human Rights found that he is in prison without lacking any grounds for criminal prosecution. And now, Committee of Ministers started infringement proceedings against Azerbaijan. That's a very, very far-reaching step. Previously, it was gentleman agreement among Committee of Ministers that they will never do so. And now it is for Azerbaijan to assess costs of these infringement proceedings. We have this with UK. You know our debate, so to say, with UK about prisoners' voting rights. For many, many years, UK refused to comply with the judgment of European Court of Human Rights in this respect, and only now, very, very recently, they changed their position. So previously the position was very firm, now it changed, and it appears that finally the judgment will be complied with. And I believe also, well, after all problems which Brexit produced, I think they could see that now costs for non-compliance with court judgments might bring them even further than that. So, and that's, so to say, well, successful, if we can say, example. But of course, backlash against the court system takes form of non-compliance with judgments, and compliance is crucial. And let me quote again Herr Schlotterpach, who back in 1945 said that pure human rights declarations without enforcement would come dangerously near to a corruption of language by creating unwarranted impression of progress. It would, in the minds of many, constitute an event that is essentially retrogressive. That was written 70 years ago, and now we have that, well, this happens. And of course, just fact of non-compliance does not reflect complete ineffectiveness of the system. Human rights law, as any other legal system, remains effective not when its decisions are always complied with, but when they are truly needed by beneficiaries, and they are needed. And the biggest threat for human rights today is acceptance of trade-offs as the only possible solution. Post 9/11 society has become conditioned by fear, and fear is always irrational and deconstructive, and some are now widely convinced that security can only be achieved by making these trade-offs, shrinking civil rights and freedoms, including freedom of movement, privacy, and liberty. And in the absence of generally presented studies about any causal link, indeed in the absence of any causal link between limitations of rights and security, the general public is persuaded that trade-offs are unavoidable. And some even seek to present European Court of Human Rights as undermining security and actively promoting interest of those who seek to bring harm to society. And far-right and populist politicians who play on sovereignty, national interest, national pride, national values, provoke hostility against the court, trying to present it as foreign and as an external interference with what they regard as domestic affairs. Human rights bodies also presented to general public as protecting only marginalized and oppressive individuals, convicts, asylum seekers, different kind of minorities, and civil society is responsible for changing this focus. And crucial responsibility to respond to current challenges is not only with the courts, it's also with NGOs as watchdogs and as educators of civil society. And of course, we should always remember that law develops with the society, and very much, I like very much the phrase by ICJ Judge Sir Christopher Greenwood, who used to say that no legal system can be better than a society itself. So this legal system serves the current society, but our role as judges in democracy is to bridge the gap between between law and society, especially when we see some warring tendencies which we observe now. And let me finish with the words by Raphael Lemkin. If you act, these words were quoted in your book, film, if you act in the name of consciousness, you are stronger than any government in the world. So I believe that our judicial consciousness guides us toward stronger response to the current challenges. Thank you very much.
Thank you very much. Justice Yudkivska, thank you very much for bringing the issue of populism and human rights. I did not publicize just Judge Yudkivska's Facebook, just, you know, for the publicizing sake, is that in Ukraine, unfortunately, the media manipulates so much with the courts without any legal arguments, like with the Ukraine's perspectives in the International Criminal Court or in the ICJ or in the CHR. So it's very important to strive to get qualitative information and analytics on those regards. We now open the floor to the questions, and I kindly remind you that there is a lady that helps, that has the mic and will come up to you first. And second, you always have a chance to ask your question either in Ukrainian or English. The translation is provided. Please do ask the questions.
Thank you. I'm Jan Glazewski from South Africa. The judge referred to the reasons why states may ratify or adopt these conventions. And I have a question to Sean Murphy in this regard. But as an aside, I was wondering when I was listening to the opening remarks whether when the Genocide Convention, states have been reluctant to ratify it, whether that is why Mick Jagger coined the phrase, "I can't get any satisfaction." But what I'd like to ask Sean Murphy is, I had a quick look at your draft, and there's no customary article saying this convention will come into force after the ratification of X states. And I was wondering if you've left it out for strategic reasons, and what is going to be the X number of states before it comes into force. And related to that is, when do these provisions become customary law? Thank you.
Well, thank you very much for the question. So the International Law Commission historically has drafted the heart of the treaties that it sends forward to the General Assembly, but it does not draft what we refer to as closing articles or closing clauses. So there's a variety of smaller articles that would deal with things like entry into force, number of states that need to ratify, amendment of the convention, and so on, that we don't do. I actually drafted up a whole series of articles of that type thinking that we did do it, and then was told by the Secretariat, thank you very much, but that's not our normal practice. I did meet with the treaty section of the UN codification, the UN treaty section, to talk about the issue and to provide them my suggestions, but that will come at a later stage. It will give the government something to do as a part of their project, assuming it goes forward. I would mention in that regard that a very important issue is the question of whether there can be reservations to this new convention. The Commission views that as part of the closing clauses, so that we are not drafting anything in that regard. But in my third report to the Commission, I analyzed in some depth the options for having a reservations clause or not having a reservations clause, because I think at the end of the day, this becomes quite significant. If you have a clause that says no reservations, some states might not join. They may have problems with their own constitutional structure that would prohibit their ability to do so unless they amended the Constitution. So that's a reason perhaps to allow reservations, but if you do that, you worry about states watering down the convention. Even if it's not something that defeats the object and purpose of the convention, it nevertheless could minimize some aspects of their adherence. You asked about how this relates to customary international law. The project that we launched consciously took the view that we were not trying to codify customary international law because a large number of the articles in the convention can't fairly be said to constitute existing law. The obligations about extradition, the obligations about mutual legal assistance would not be viewed as customary in nature. Some aspects might be, and in the course of our work, we try to identify places where we, as the Commission, think it's customary international law. You might have noticed that in the preamble, there's a preambular clause that says the prohibition on crimes against humanity is a peremptory norm of international law or jus cogens. So that's an example of us making a claim about the current status of the prohibition. But as a general matter, we haven't tried to declare that all this is customary international law, which has allowed us to be fairly creative, I think, in the way that we structure the convention, and hopefully will allow states to be open to joining the convention, in part because in the absence of the convention, some of these obligations probably do not exist.
My name is Hans-Christian Jasch from Berlin. I'm a lawyer and I'm heading the Wannsee House Memorial where the Wannsee Conference took place. I have two small questions. One is the question about this general criticism that the concept of genocide is used in political terms, has actually been overstretched in some ways in order to refer to certain situations or to make certain situations fit a certain political situation or to call for intervention in political situations. I would like to hear your opinion on this. And Judge Yudkivska, I was very interested. You said the courts cannot be better than the society. They.
That's not me who said
Yeah, but
that.
you referred to this quote, and I think this is a central challenge in Europe. You mentioned that we are seeing a situation where not all the members of the European Convention on Human Rights will be democracies anymore. In fact, we have some countries which still consider themselves democracies, but which seem to be on a slippery slope. Often we speak about the lessons from Weimar in this context. And there has been long time that, for example, Turkey and also Poland were heading the list of countries which have been convicted, which can be an indicator for a very vivid legal profession in these countries and for a vivid civil society. But what I would like to know is what is happening in terms of the implementation of the judgments. Do you have feeling that governments are still following this, or is there a general, I mean, even in Germany there have been cases about the question of imposing custody on people who are considered to be re-offenders, yeah, which is a very problematic issue. The implementation is still ongoing on establishing, and I wonder how is this monitored in Strasbourg?
So on your first question about the issue of the crime of genocide at times being looked at as having a political dimension, and I take it in part the question to me is, what do I think of that? But how does that then relate perhaps to crimes against humanity doing a similar convention? Will this be viewed by states as, oh, don't call something crimes against humanity because that might then obligate us to do something like intervene in another country? I guess I would direct attention to the draft Article 4 for those of you that have the handout in front of you. This is the obligation of prevention article that some of us have been talking about on the panel. And the language here in draft Article 4 somewhat tracks the Genocide Convention, particularly the words undertakes to prevent undertakes to prevent. We actually had a debate in the commission, should we say each state shall prevent rather than undertakes to prevent. And we consciously made a decision to parallel the Genocide Convention language. We did see the treaties as having a certain amount of affinity to themselves, being sort of sister or brother treaties. But notice the very next clause, each state undertakes to prevent crimes against humanity in conformity with international law. That was inserted at the request of several members of the commission in the drafting committee to try to highlight that there's an alternative set of rules of international law that are out there relating to the use of force, and that you must be operating consistent with those rules, and there's nothing about this convention that alters your rights or obligations under those rules. Chapter 7 is one way in which there might be an authorization to intervene in another country, perhaps because of crimes against humanity. There are doctrines. Laurie Damrosh talked about the responsibility to protect doctrine, and the earlier version of that doctrine, in part, might be said to be the doctrine of humanitarian intervention. So there's debates about whether responsibility to protect, humanitarian intervention are concepts of international law that allow you to intervene consistent with rules on the use of force, even in the absence of Security Council authorization. We don't really try to answer that question here. But we are signaling quite clearly in conformity with international law. Don't assume that this convention is giving you a right or an obligation to intervene inconsistent with rules on the use of force. You have to go to that other domain to fully answer that question. So it's an important one, but my hope is that this would not be construed as a treaty that's trying to alter the existing situation, because I think that could lead to a path of states worrying that by joining this convention they are somehow obligating themselves to intervene. There's a slightly different issue, which is, are you obligated yourself not to commit crimes against humanity? Answer, yes. The government cannot itself commit crimes against humanity, and that comes in part out of the International Court of Justice's decision in the Bosnia v. Serbia case, where they said this language, undertakes to prevent, means not only do you need to stop your army from doing it, but you as a whole, your government, must take steps not to make this happen. And then even more interestingly, you must use influence with others, other states, non-state actors. You must use whatever influence you have to try to make sure they don't commit crimes against humanity. And that came up in the Bosnia v. Serbia case in the context of the government of Serbia influencing, to the extent it could, Bosnian Serbs not to commit this crime. That too is a part of this obligation, and that may give governments pause as they join this, but I think it should give them pause. This is something that they should be doing to the extent that they can.
Well, thank you very much. Of course, enforcement is a crucial part of the system, yeah? And we have special body, Committee of Ministers of the Council of Europe, which supervise enforcement. And now, of course, the states are reluctant. The more politically sensitive, so to say, judgment is, the more state is reluctant to enforce. But this reluctance or resistance even can have different forms. Some states are just protracting enforcement. They said, well, we are preparing, we should change legislation. It takes time. Obviously, it takes time, that's clear. Some states says, well, we believe that we already enforce. We change the practice, we change legislation, and then it's up to Committee of Ministers to assess and to say, no, sorry, it's not enough. But there are, of course, very radical forms of resistance, like, for instance, Russia demonstrates. Russia recently passes a law according to which it's up to the Constitutional Court at the end of the day to say if judgment by the Strasbourg Court should be complied with, if this judgment apparently violates, as they believe, Constitution of Russian Federation. And this is very, very serious threat for the whole convention system. And you know, it's very difficult, of course, only for Council of Europe to be responsible for enforcement of human rights, for the Committee of Ministers to supervise. Judgments are much better enforced when there is additional pressure on the governments by civil society, because our judgments is also instrumental for NGOs, for civil society to bring pressure on the states. And we can see how effective it is when they do so, and that's precisely the reason why repressive regimes we have now in Europe start with NGO, lone foreign agents in Russia. In Turkey, you know, they imprison all human rights defenders. In Azerbaijan, they imprison all human rights defenders. So civil society plays really crucial role in protecting human rights, and including enforcement of our judgments. And I'm terribly sorry, but with this I have to say goodbye to you and to wish you a very successful further discussion, because we have a parallel event with my fellow judges from the court, and thank you very much. I was very happy to be here. Thank you, and I will see you tomorrow.
Dear guests, does anyone else has a question? No? Are there any more questions? Okay, thank you so much for your participation, for your patience. And what I particularly like about this panel is that we sort of, all of us practicing lawyers, members of the parliament, of the authorities, people from the political science, from academy, from the civil society, sort of got to the home task, what to discuss and what to foster at our specific places of employment. So I hope we do that. And I'm particularly speaking to my Ukrainian colleagues about the implementation of international crimes and crimes against humanity under our domestic criminal legislation. Thank you very much. And the next discussion starts in about 12 minutes, but I think we still have some time for a break. Thank you.